hand me my screen box?
Okay, who are you, sir?
President.
Okay, do you know this man, Mr. Grove?
We
You've met him before? You're acting bewildered. You've never met him before. You've never seen the man before, have you?
no, sir, we've spoken on the phone.
All right. He is your attorney. He's been appointed your attorney, at least for the time being. All right, you are charged in this indictment right here. See this? There's an indictment that the grand jury's returned. It states in summary that on or about June 29th, 2023, this year, in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. This is a third-degree felony. If convicted, you face no less than 2 nor more than 10 years in prison and a fine up to $10,000. Do you understand what you're charged with and the punishment range that's applicable here? Okay. All right, so serious. Have you ever been in trouble before? You're looking around like that means a yes. For what?
Unlawful carry.
Unlawful.
He's on probation now, I believe.
Really?
For unlawfully carrying a weapon and misdemeanor, Judge.
Okay, well, that's the misdemeanor is still a crime. When did you get placed on probation for that?
December 2nd, 2022.
All right, well, then you've got 2 fires to fight. You've got that fire where your probation could be revoked and you could be sentenced up to 1 year in the county jail for a probation violation. But that's for that judge to decide. You're here on this felony. All right, you need a lawyer. Now, he's been appointed, but you're supposed to, like all of us, take care of our own mistakes. Your mommy doesn't take care of them. Your daddy doesn't. Yeah, it's you. You're a grown up. So you got to take care of your mistakes. That's all about maturity. So what are you doing to get some help? Do you work somewhere?
I'm trying.
You don't work? You're not employed? Well, you're trying. Where have you worked, Ryan?
I was working at camps.
Doing what? Whatever they got you to do. What are you doing right now to get a job?
I tried to get my Twig card, but they rejected.
Okay, let's say you don't get the TWIC card. What are you doing? What's your backup plan to get a job to pay for your mistake? You got to pay. When we make mistakes, we got to pay for them. All of us do. So,
I'm applying for jobs.
how many jobs have you applied for in the last 2 weeks?
Over 10.
Over 10? Okay. Well, you got to work hard to do that because this is a problem, an issue that you're going to have to pay. It costs when you make a mistake under law.
Your Honor,
Is this your signature? Give it to me. Is that your signature right up there? Okay. So they talked to you whenever you were arrested. The magistrate must have talked to you about your income level, and I see that you have 0 income right now. Is that right?
Yes, sir.
Well, you're in a mess. You need to fix it. You understand, sir? Have you ever been in any other trouble other than that?
Well, not this. No,
Raise your right hand. You solemnly swear or affirm the statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, subject to perjury. So help you God. Lower your hand. Have you ever been in criminal trouble before? Ah,
Good traffic tickets, haven't you?
is that it? Just traffic tickets? Is that it?
I
No.
never been convicted of that. I never convicted.
What did I ask you?
So
There you go. Well, you're presumed innocent when you're charged with crimes, but I want to know what you've been charged with.
I've been charged with unlawful carry.
and
And that's all? Don't get any help from the crowd.
If I'm on my best.
That's it.
Judge.
All right. Hold on. What do I have?
Charges have you been arrested?
I'm showing your honor that he was arrested after this incident
State jail felony?
for state jail felony possession of controlled substance. After his being placed on probation, he has an additional charge for UCW. In addition to that, we have records showing that he has a juvenile history out of California as well.
Is that it? Is that true? When were you going to tell me about that? Sit over there. Right over there. You're in timeout for a while. We're going to take care of you here after we look at some of. Can I get a copy of that?
Yes, sir. I'll get you a copy of that.
Oh, hello. Oh, hi. Yeah. No, I said hello to you too, but I'm looking at this indictment. I've never seen so many convictions. How many theft convictions do you have? Do you know? What does it say about someone they don't even know? There are how many convictions they have? Yes. Yes.
9.
16. That's in courts of law that are courts of record. I don't know how many JP or Class C misdemeanors you have, but you got 16. I don't think I've ever seen one so long. And so here we are today with a theft. You understand? If you steal, like I tell the label, a pack of gum, it's a felony from now on. Do you understand? Yeah, that's what the way the laws work. That you make so many mistakes, and you have to pay a higher price. All right, yeah. Are you retained on this?
No, yeah,
I'm not surprised. You're appointed. So now the taxpayers are paying your way along for your mistake. What do you think about that? Or do you feel? So what are you doing about it?
I'm
Ma'am?
trying to fix my life.
How? What are you doing?
Uh,
It's always fixable. Never too late. So
right, you're right. Since I've been out on bond and stuff.
yes, ma'am.
I've been studying continuing looking for a job. I've been doing my own meetings, my AA meetings.
Oh, okay.
My AA meetings. I've been doing my new.
Is it alcohol that's your problem or drugs? No.
And actually, to be honest,
Oh, yeah, that's a good thing. Being honest with the court is always is advisable.
by you putting me in jail that day, you saved me.
So, but when did I do that?
She was out on bond, Your Honor, and she came in for a bond docket today, and in Chester, she was positive we were in jail. She was, how long were you in jail? Months?
Yeah.
Yeah, she was in.
Okay. What was the bond?
It was it started out at 10 and then it got to 20.
So how'd you get out?
She was able to finally get,
I mean, you're too poor to hire a lawyer, but somebody got your bond, huh?
My mother was
Your
sick,
mom?
and she
Your mother?
Yeah.
She's got to pay her own bills. She doesn't need to be paying for your mistakes. Hold it. I shouldn't ask a lady that. You're not much younger than me. You're not much younger than me. Don't tell everybody. They'll know my age. Trying to tell everybody I'm still 30 something in dog years. Yeah. But really, this is ridiculous. This is way over the top. HEB, huh?
yes, sure.
God bless you. I mean, yeah, I'm pretty lenient with this sort of thing. I mean, if you're picking up, food, but it's coffee makers, you're just trying to steal. Those are expensive, because they're really good things. They make great gifts at Christmas, by the way, John.
I'll remember that.
For you, for your family. All right, look. What we're going to do before we reset anything, we're going to go through the round and sit over there, and then you have another one.
No, that's the only one I have, but we'd like to put this on the trial.
Yeah,
We've already been on discovery several times and we
all right,
want to try.
all right. John West is a very good lawyer. You probably know that, and he can handle your case. It may go to trial quicker if you agree to release him, but we could put somebody today from the trial docket wheel, but it's your call. If he had to try everything, it would take a while, but we can get somebody off the trial docket wheel, which is quicker, but it's your choice. Nobody influences you. You have to it's your choice. It's your choice. Don't get John can't help you, or he gets in trouble with the Indigent Commission, and so do I. We can't nudge you because it's your choice. What do you want to do?
Okay.
You keep him? Well, he's a very good lawyer.
And
I don't think this would take.
I would like to keep this one, Your Honor. I don't know.
All right,
I'd like to
and
kind of
you will
take
continue to be the
well,
attorney of record. All right. But just have a seat before you leave and get a resetting. Thank you. Rashad Johnson.
All right, we're on the record in the matter of the city of Wyandotte versus Corey Van, 231833.
Morning, Your Honor.
Good morning.
John Bain Jr., P 37753, appearing on behalf of Mr. Van, who stands to my left. Mr. Van, please state your name for the record.
Corey Patrick Van.
All right, thank you. Change the date scheduled for sentencing in this matter on your client's plea to assault and battery. And is Mr. Vegan in the courtroom? No? Okay. All right, and counsel, did you have an opportunity to review the report and recommendation with your client?
We have no additions, corrections, or deletions. Any fines that you impose, as well as the probation oversight fees, we're going to pay in advance. I do want to point out, Your Honor, that on the date of this incident, Mr. Van had been on the lake all day, came back to the dock, was stone cold sober when he got back to the dock. When he got back to the dock, he did have a White Claw. The victim had been drinking on the lake all day, was highly intoxicated. At one point, the victim asked for a beer. They gave him a beer. He then asked for a second beer, and they said, "You've had too much to drink." And he got mad, and he crinkled up the beer can, and he threw it in the boat. My client's wife was in the boat, cancer survivor, three other adults, and Mr. Van did push him into the water. He shouldn't have touched him, but he did. We'd ask that you adopt the report. I would ask that you waive the no alcohol provision. This was not an alcohol-related situation, Your Honor. It just wasn't. I mean, as to the drug provision, he's not supposed to do drugs anyway, so certainly it would be reasonable for drug testing. Anger management, you should have touched the gentleman. Anger management's appropriate. And then when we were here last, we had disclosed to Your Honor that Corey and his wife had made prearranged plans to go on a big trip to South America. I have the itinerary in my hand. They were hoping to leave on October 30th. They get back on October 11th. Yes, we'd ask that he be allowed to leave the state for purposes of
Let's go with the itinerary, please.
going on this trip. And then as to any conditions you impose, Your Honor, he's going to do whatever you tell him to do. I've known him for 20 years, represented him on business matters. He's not a big drinker. This was not an alcohol-related incident for Mr. Van's point of view. I mean, had he been too drunk, we'd tell you, Judge, he was highly intoxicated and, was alcohol-related, but this one wasn't.
Okay, and I hear what you're saying, counsel, which quite frankly, makes your client's actions even more incredulous. So your client is stone cold sober. There's somebody that is intoxicated and he pushes them into the water. Then the individual is trying to get back up on the dock and your client pushes them back in the water.
That actually let go of his hands, but yes, Your Honor, I'm not
And with the fact that this individual was intoxicated, and as you're indicating, severely intoxicated, to push him into the water, your client's lucky he's not looking at homicide charges. I mean, it's very fortunate that the individual didn't drown.
I understand, Your Honor. Last time and this time, we've completely acknowledged that Mr. Van should not have touched this gentleman. So I'm not trying to minimize the fact that he touched him.
Your Honor, may I speak?
Okay.
I was trying to help him out of the water, and the reason I let go of his hand was because he was threatening me and telling me he was gonna kick my ass, and I let his hand go. He went back in the water.
Oh, sir, you just pushed him in the water. You don't think he's going to be upset? Whether or not he's sober or not, you don't think he's going to be upset?
Yes,
And then, given the fact that he's intoxicated and probably has less of a filter, given the fact that you just pushed him in the water. So you're trying to help him out apparently, and you didn't like what he said, so you let him back in the water. You just dropped him back in the water, pushed him back in the water. However, he ended up back in the water. All because apparently an empty crushed beer can was thrown in your direction.
yes, ma'am.
And some of which were both very.
I'm sorry?
It was more than just a beer can, but we acknowledge that he shouldn't have touched him, Your Honor. I mean, he was belligerent, profane, I mean.
Did you know this individual?
I met him occasionally. He is, the people that are in the slip next to us that we were out with all day. It's the owner of that boat's daughter's boyfriend. I've met him, I believe, 3 other occasions. And there was the time before, the last time I had an encounter with him, it was the same thing.
Well, it wasn't the same thing.
Well, no,
You didn't touch him.
I didn't touch him that time, but he was threatening me. Told me he's gonna kick my ass, and I don't know, his father works in the same industry that I do, and so he has a little bit of a knowledge with the industry, and just being obnoxious, telling me I don't know what I'm doing, and
So when you have somebody like that, sir, just ignore them. When they're drifting, ignore them even more.
We agree, Your Honor.
The court, after hearing from counsel and hearing from Mr. Van, reviewing the report, the recommendation, the court does find there's reasonable grounds to depart from MCL 769.5. The court's going to indicate 12 months probation. You are eligible for early discharge with a hearing. The court will note that you are also eligible under 771.1 status, not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. The court will note that you do have this trip planned, that apparently you booked it on September 5th before you even came to court the first time. Ma'am, whether it's booked or not, there's an email from September 5th and you're not identified for the record. So,
What did you say? Just tell us.
well, the point is it was booked prior to the
Yes,
first court date.
yes.
I'm just trying to make a record that that's what, that was booked prior to that.
the planning started over a year ago.
All right, the court will grant you permission to travel for that. Sir, if you behave like that in South America, you probably won't be coming back. So hopefully you have it together that you're not behaving in that manner
Yes, ma'am.
or that fashion. If somebody's belligerent, let them be belligerent and walk away. Mr. Mermisar, please hit join. The court will note as well, you to report truthfully to your probation officer. The office of your probation officer may require in person, writing, or virtually. You're notified probation officer immediately of any change in address or employment status. The court's going to order no alcohol or drug use unless prescribed to be subjected to random testing. We can revisit that, counsel, at some point, but for now, that's what the court's going to indicate. The rehabilitative goal for that condition is to monitor your progress and maintain the absence of sobriety. I understand that you were sober for this event, sir, but if that's how you behave when you're sober, I would be more concerned with you're not. You're to participate in the, I'm not going to order the chemical awareness program. I am going to order you to participate in the anger management program I don't believe 1 day is sufficient, especially given the fact that you have a prior malicious destruction of property. That tells me that you still have some issues with how to handle upsetting situations. So the court's going to indicate 8-week anger management program. The rehabilitative goal for that condition is to assist you in expressing your feelings and needs in an appropriate fashion and to prepare you for upsetting situations. Now, to have any contact with Kyle Vegan, and there's no restitution requested at this point. If there is restitution requested later, it would have to be in the form of restitution hearing. Any questions regarding the terms and conditions?
No, ma'am.
All right. And as to the fines and costs, the court will indicate a $400 fine, $100 screening assessment fee, supervision oversight fee of $600. It's 12 months at $50 a month. Since you're eligible for early discharge with the hearing, so up to $300 of that may not be due. $200 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50 for a total of $1,325. And counsel, I think that you said that your client had money to pay today. I don't know if you indicated an amount. Did you indicate that your client has money to pay today or no?
Yeah, he'll be paying today everything.
Okay, so let's hold off on 300, so keep that back. So it'd be $1,025 today. All right, sir, when you're done here, you're going to have a seat over probation. Somebody will be with you shortly to address the terms and conditions. The court's going to also indicate, as I did, that you're eligible for early discharge with the hearing. You can request early discharge if you've completed all of your terms and conditions. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort toward making full payment. Okay? Thank you. Have a good day. Somebody will be with you in just a few moments. All right, I take a brief recess.
And this is Cesar Mera. That's you, sir? Cesar Mera and Sorrento. 20-34081 is called. You were here with Mr. Grove, your attorney and the state's attorney. There is a first amended motion to revoke probation in this, right?
Yes, sir.
Does the defendant waive a formal reading of this and we proceed in summary?
Yes, Your Honor.
In summary, this first amended motion to revoke unadjudicated probation filed on September 1st of this year states that on August 12th, 2021, in this case, you were placed on deferred or unadjudicated probation for assault on a public servant. Is all of that true and correct?
Yes.
You can say this agreement was.
On the tablet today, it shows up for November 9th, but I know that they signed it last week on October 9th as well, Judge.
You have it, Judge? I have.
Nope.
one That says.
I don't have October 9th. What in the world are we doing with November 9th?
Well, this was set for a hearing, Judge, and this plea is coming from that.
I don't have anything on the queue past
I know,
today.
I'm signing it, Judge. Well, I'm fixing the dates.
All right, which allegation is he pleading to? Which one? Is it number 2?
Judge, the only one that deals with an offense, I believe, is the first amended count 2 and count 3.
Well, let's just do one.
The other ones, I think they're all.
It only takes one.
Count 2, Judge.
Two states that you committed the offense of taking a weapon from an officer on or about August 8th, 2023 in Kendall County, Texas.
Judge,
Is that still pending?
Yes, sir.
Was he pleading true to that or not?
no, sir, I would ask the court not to let him plead for some of these other ones that are administratively.
Committed the offense of resisting arrest on or about August 8th in Kendall County.
He also has a urine test. He has not performed his community service hours. There are some other grounds, but I would rather not have him plead to take his weapon from an officer
Let me ask you
in
on
Kendall
this.
County because I am not. I don't represent him there.
What's the deal on it? What's the deal?
The deal is 5 years.
5 years. Just
Well, this is serious. This is, I mean, a repeated allegation. Well, you pleaded true to this indictment, which was causing bodily injury to a peace officer. Now you've got on my watch here, while you were under this court's probation, taking a weapon from an officer and also resisting arrest.
Those are both out of the same incident. He was in a tussle with the officer there and
It sounds bad to
resisting
me.
the arrest and taking his taser is what he did, Judge.
Well, that doesn't sound good to me. It sounds kind of like you can't, you fight with police officers and you don't respect authority.
Judge, I'm not trying to tell the court the entire thing, but there was also some indications from talking to the people in Kendall County that he had some mental problems. He'd be reported that he'd been taken to a mental hospital
Did they
in San
indict him?
Antonio.
They did. They evaluated him and he had been released. So that I can affirm that's true. But I can also affirm from talking to the witnesses on this that they took every method to work with him and he was just unreasonable. He was uncontrollable on that day, Judge.
Judge,
That
I'm
didn't sound
concerned.
good.
No, sir. But I have talked to the officer. He is available to come for the hearing date. He knows that we have this agreement. He approves it. I'm asking the court to approve it. My preference is that he at minimum enter a plea to either count 2 or 3.
The one in this indictment,
No, they all.
one's out of Kendall County.
Yeah,
We got
one's
a lot
out
of
of-
officers here involved in as victims, it sounds like.
I'm referencing my comments are about the officer out of Vernon. I have not recontacted the officers in regards to this agreement. I was in contact with them before I gave the probation offer that I did to Mr. Roebuck on this case originally.
And then there, not the least of which here is he's showing positive for cocaine.
Yes, sir.
Where was that?
That was here in Jefferson County after he was arrested and brought back to Jefferson County.
Okay.
And appeared to
Well, they brought
probation
him pretty
department, I believe.
Brought him pretty quickly. And so he was in custody in Kendall County. Then they brought him here. Right.
He was in a mental hospital from August the 8th until August the 14th. And he was released when he came to report to us on August 17th.
Oh, okay. He was not. Okay. Well, how did he, on the assaults, what do you do, bond out?
Well, they took him into a mental health evaluation from this incident.
And then they just released him. They didn't pick him back up?
They picked him up and brought him back to the hospital. And then he was committed to the mental hospital.
I believe he was released from the mental hospital.
And then what did he do when he was released from the mental hospital?
His family brought him back here.
Yeah. And then he shows positive for cocaine on the way. He stops and gets him some cocaine.
Either that or it was in his system from the.
For a week? I don't think
I don't know.
so.
Well, Judge, he was, I don't know what he took. I don't know what.
I'm not naive
He was
to
in the
that.
hospital for a week. Judge, I just feel very reluctant because he does have that other charge.
Yeah.
Now, I'm not saying that your charge is not serious because it is serious.
60% report?
Yes, sir.
No, he's looking at 20 years in prison. To me, I find
Yes.
that pretty.
Let me find this, Judge. I thought I had.
This is, but fighting with the police is ridiculous. Ridiculous. On probation, fighting, so you're on probation for it, so you quite naturally fight with the police. And then you're tested positive for cocaine. What do you do right? All you do is you're committing all kinds of crimes.
Yes, sir. I'll do 13 when come to the hospital.
Shame on you.
Yeah,
Where'd you get your cocaine from?
No one.
Oh, okay. So you tested positive for cocaine and you don't know how that happened? It was a miraculous event?
Yeah, because I
A miraculous event.
But you know, I did the wrong stuff. And I apologize for it.
Wait a second. Okay. He was on 5 years deferred probation before he even came to us for assault on a public servant. In here, in this county?
I don't think that's right, Judge.
I
Well,
don't
that's what
believe
the
that's
pre-sentence
correct.
report was.
He had a prior DWI.
Can you check? Are you from around here? Are you a citizen of the United States? Are you a citizen of the United States?
No, sir.
No, Judge, this one that you're referencing, that's the offense that he's on probation for. All of those arose out of the same incident and we resolved it as one probation.
No, that's not fine by me. No, and to compound it that you're not even a citizen of the United States. We welcome you, and all you do is assault police officers and take cocaine. No, shame on you.
Sir.
Shame on you. We'll set this for a hearing on motion to revoke probation hearing. And we'll see what happens and we'll go from there. I'm not accepting the deal here on this.
Yes, sir.
This is not appropriate behavior for anyone, citizen or non-citizen, but you, shame on you for not following the rules. All right, I'm gonna set it in 4 weeks. Tell me, and if you can't be ready, let me know.
Yes, sir.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.